The question is that Amendment 1 be made. David Davis.
Yeah. Thank you, Mr. Chairman. Remember the pro forma. Can I start by agreeing entirely with my right honourable friend for Chingford and Wynford Green? He's argued forcefully that we should not extradite to China and Hong Kong with powerful humanitarian and human rights reasons, and he's right on every count. Now, our extradition arrangements with the United States are not anything like as divisive as they are with China and Hong Kong, but they still remain deeply imbalanced and can lead to serious miscarriages of justice. As it stands, this bill would allow for the arrest of individuals in the United Kingdom who are extradited to a list, or are to be extradited to a list of specified countries, to arrest them without a warrant. My amendments would remove the United States from that list of countries. That's Amendments 7, 8, 9 and 10, and that's what I shall speak to now, Mr. Chairman. The government says we need the powers in this bill because of suspects getting away if they are, I quote, encountered by chance, close quotes, and it's not possible to arrest them without applying to a judge for a warrant. But for hundreds of years in this country, we have woken judges and magistrates up in the middle of the night to do precisely that, to carry out a police action, whether it's a search or an arrest. And we do not bypass normal legal protections when a domestic suspect might get away. So why is it necessary for individuals facing extradition? The Home Office's own impact assessment of these new powers say that with or without these powers, suspects are highly likely to be before the court in any event when the requesting state confirms the suspect is at large in the UK. So you have to wonder why they need it at all. The methodology used in the impact assessment supporting the bill is both opaque and bogus. It's too long to go to it here, but I would recommend, if you want a confusing way to go to sleep, you should read it. It's completely useless. But even so, it asserts the proposed change would only result in just 6 individuals per year entering the justice system more quickly than would otherwise be the case. 6 individuals a year out of over 100,000 criminals we deal with in this country every year. And for that, we're giving away a fundamental legal protection to the innocent as well as anybody else. The explanatory notes to the bill try to justify the legislation on the basis it's similar to powers introduced by our European neighbours. Spain, for example. Well, let me give you a single example of that in operation. The House will know the name of Bill Browder, the man who campaigned on behalf of Sergei Magnitsky, the man who died in Russian imprisonment, effectively was killed by the Russian state. The Russians put out a red notice in Interpol for Mr. Browder, and the Spanish government executed it. Now, right enough, a judge subsequently released him. But I'd like the House to think how Mr. Browder would have felt sitting in a Spanish prison, considering the prospect that he might just be about to be extradited to be imprisoned in Russia, to be put into the hands of the people who had killed Magnitsky. So these things are not without price. As for other European countries, well, of course, a number of them actually have absolute embargoes on extraditing their own citizens to anybody outside the European Union. For reasons which I'm going to come to in a second, but which will essentially relate to a lack of trust of other countries' justice systems. The bill's impact assessment states that under the proposed new power, the police could arrest a suspect who was wanted for extradition by a trusted partner country. And the bill defines a trusted partner country as those who respect the international rules-based system, and I think broadly speaking, not entirely, but broadly speaking, the United States does that, and whose red notices and criminal justice systems the UK trusts. Now, we like to think of the United States justice system as being rather similar to our own, but recent high-profile cases have highlighted just how wrong that is, and how we cannot trust the system with the interests of British citizens. When the 2003 Extradition Treaty and the associated bill was introduced, it was sold to this House on the basis that we used principally for paedophiles, murders and terrorists. I was the Shadow Home Secretary at the time. I remember it vividly, and I remember the leader of the Conservative Party at the time actually accepting it on those terms because he thought it was in the interests of the country. But the people we're extraditing to the United States are mostly white-collar businessmen who pose no danger to the United Kingdom or indeed United States citizens. Since
Will my right honourable
you want, yes, I give way to my friend.
I'm most grateful to my right honourable friend who's making a characteristically sensible and robust speech. Does he agree with me that at the moment the international rules-based system is under very great pressure, but matters a huge amount to all of us? Isn't the example he's giving of the United States a totally asymmetric approach to extradition? And that asymmetry will be seen by our constituents and seen by people in Britain, will be seen as being most unfair and will be seen to bring this whole process into disrepute.
Well, he's right on several counts. I'm going to elaborate the unfairness in a second. But he's right also to highlight something else, and that is that rules-based systems, international rules-based systems, only work if everybody sees them treating all countries and the citizens of all countries in an identical way. If they don't do that, they fall down. So if you take an American exceptionist approach to this, you destroy the system that you're trying to uphold. So there is a rather interesting philosophical point in his intervention, as well as the moral one that I'm going to major on.
Would he give way?
Of course, I give way to my right honourable friend.
Would my right honourable friend confirm that there were quite a number of us on the opposition benches when these measures came in who were very uneasy about the asymmetry and the unfairness, and so it's good to see him reviewing this at this later date.
It's exactly right, and I was one of them, although at that time I was not allowed to say so. It won't be the first time I was overruled by my boss, or indeed the last. Since 2007, the United Kingdom has surrendered 135 UK nationals to the United States, 99 of whom were surrendered for non-violent offences. Overall, for the whole period of the Act, it has been 80% non-violent offences, so much for terrorism and murder and paedophilia. Or to put it another way, only 3 violent offences per year requiring extradition to the United States. The US deliberately uses its extradition arrangements to cast a wide legal net around the business world, seeking to be judge, jury and executioner for global commercial deals and global commercial aims. The Home Affairs Select Committee's 2012 report concludes, the United States has the power, and I quote, has the power to reach out around the world and, provided there is a very, very tenuous connection with the United States, it generally has the power to prosecute. And the distinguished extradition lawyer Robert Duggins puts it, the Department of Justice effectively uses criminal extradition as a lever for US interests in commercial matters, which is not what it's for. This has been shown in case after case. Cases such as Ian Norris, the chairman of Morgan Crucible, the NatWest 3, Christopher Tappin, and a number of others, including most recently Dr. Mike Lynch. How does it work? Once a person extradited from the UK arrives in the US, they're treated as guilty from the moment they land. They face invasive strip searches, and that is exactly how it sounds. They are electronically tagged. They're kept in appalling conditions, completely alien to the British justice system. They're shackled and perp-walked into and out of court in front of television cameras and paparazzi, so the US Department of Justice can claim a PR victory at the expense of the presumption of innocence. Some of them sit in court facing the allegations dressed head to toe in orange prison garb. They're then faced with enormous pressure from the US authorities to agree to a plea bargain. They're told if they plead innocent, they'll face decades in these appalling conditions, and if they plead guilty, they'll receive a much lighter sentence in an open prison, possibly half of it served back here in the UK. Because the case is held in America, very often witnesses from the United Kingdom will not appear, as they themselves fear incarceration. That's certainly the case in some current cases. A massive 97% of cases are settled by plea in the United States. This, for a foreigner, unprotected by the US Constitution, for a foreigner, this is not a justice system. It's a very effective, but not at all fair, prosecution system. It's not justice. Much of this would be better if the accused were tried in Britain, completely sidelining the need to extradite at all, to come back to this bill. The NatWest 3, for example, were British citizens. Their alleged crime was in Britain, against a British company. At worst, they should have been tried in front of a British court, but the British authorities did not see them as having a case to answer. but the extradition treaty does not recognise this. Anyone caught in this system faces an asymmetric and unbalanced treaty process. Unlike the US, a person in the UK has no right to insist on probable cause before being extradited. The 2011 Joint Committee on Human Rights report called this a lack of reciprocity in the treaty, and it's resulted in the US only surrendering 11 individuals to the United Kingdom since 2007, whilst 135 have gone the other way. And since the United States is roughly 5 times our size, as big as the UK, this is a disparity, an effective disparity of 50 to 1 in risk of extradition.
Well, my right honourable, let me.
I will, of course.
It's not just a case of lack of reciprocity, though, is it, Madam Chairman? It's the fact is that in the NatWest case, which he mentioned, these people had no case to answer, according to the British authorities, and yet, in spite of that, they were extradited. That surely is an appalling abuse of their human rights.
Well, he is exactly right. I mean, there were other cases. Interestingly, in their case, human rights were not used as a mechanism of defence. In another case, the Gary McKinnon case, that was the only thing that stopped Gary McKinnon from being extradited, was the actual implementation of the human rights law. But he's right more generally. They didn't have a case to answer in a normal justice system, but they gave in and confessed to guilt rather than face 30 years in a grim, high-security Texan prison, never seeing their family again, which is what it would amount to. So that's where the disparity is and why it's so unfair. And the US government, of course, has much greater discretion in refusing an extradition request. The British Extradition Act says the Secretary of State must, the word is must, issue a certificate for extradition. The equivalent US code states the Secretary of State may order the person to be tried. May order. And of course, there's no stronger demonstration of this than the case of Anne Secoulis, the person responsible for the tragic death of Harry Dunn. In Ms. Secoulis' case, the US Secretary of State has used this discretion to prevent her extradition. And I think in the view of most of this House, wrongly to prevent her extradition. The Dunn family may now have to settle for a wholly unsatisfactory virtual trial of Anne Secoulis because our extradition arrangements have failed to give them proper justice. But this is just the latest example of how the completely lopsided treaty allows US citizens to evade justice while exposing United Kingdom citizens to miscarriages of justice. The Prime Minister himself has recognised this imbalance. At Prime Minister's questions on the 12th of February, he said, "I do think that elements of that relationship are unbalanced, and it is certainly worth looking at." Now, due to the scope of the bill, my amendments wouldn't rebalance the extradition arrangements with the US. They would, however, prevent, in a very, very small way, further facilitation of further miscarriages of justice. It would be a tiny improvement in a system that requires an entirely radical rewrite. And so I'm only putting these as probing amendments today. But the simple truth is, and I make this point very, very firmly to the Minister on the bench, my right honourable friend, my very old friend, the Minister on the bench, that this really needs, he's older than you think, this really needs, in the words of the Prime Minister, a rethink. And I do hope that the government will rethink this treaty and ensure that in future, when we extradite British citizens to any other justice system in the world, that justice system will work as it is supposed to and give them what's in the title, justice.